Hey guys, today we're going to talk about enforcement of judgments. So, after you win a lawsuit and you get a judgment, whether it's Order 13 default judgment or Order 14 summary judgment or a judgment at trial after trial, you will still need to enforce it. Money doesn't just drop from the sky, you know. The court is not going to pay you the judgment sum. So you have to enforce the judgment against the person who lost the lawsuit. In other words, the person who lost the lawsuit and has to pay you is called the judgment creditor. Enforcement of a judgment can include freezing bank accounts to seize the money in the bank accounts, or seizing assets and auctioning off the assets, seizing private property and auctioning off the private property if the bank consents. Or the last resort is bankruptcy, where you bankrupt the individual, or in the case of a company, it's called insolvency. So most of the time, the judgment creditor will not pay immediately, so you will have to take out one of these enforcement actions. The first one is called writ of seizure and sale. I will call it WSS for short. WSS is a court order for the bailiff. The bailiff is an officer of the court to seize the property of the judgment debtor in order to pay the judgment debt. The court seizes such property through the bailiff. Basically, what the bailiff does is he will go down to the house, for example, or the office, and accompanied by a representative of the plaintiff. The plaintiff will point at assets to be seized, for example, sofa, fridge, TV, computers, whatever. The bailiff will put a sticker there, make an inventory of the items that are seized, okay? The judgment creditor will be given 7 days to pay up the judgment sum. If the judgment creditor still does not pay the judgment sum, then the bailiff will call for an auction of the items that are seized. Now, HDB flats cannot be seized under a WSS, but you can seize the contents of an HDB flat. So you can seize the sofa, the TV, the dining table, the chairs, if you are lucky, you may see a Rolex on the table. You can even seize the Rolex. You can WSS equipment. What usually happens is the court bailiff will go down to the premises. If the premises are locked or the owner is not in, he will paste the notice on the door stating that they have made the first attempt. A second attempt will be made, and during the second attempt, if nobody is at home, they will bring along a locksmith to cut open the door for the plaintiff to choose which items he wants to seize under the WSS order. The next enforcement option is called garnishing. Garnishing is to get the third party, such as an employer or a bank, who owes money to the judgment creditor. So this is a judgment creditor. Somebody owes money to him, okay? So garnishing proceedings are obtained so that instead of the person, like the employer or the bank, paying him the money, you get the employer or the bank to pay the plaintiff the money instead of the judgment creditor. The most common way of garnishing is to garnish bank accounts, but you need to know the bank account number, and you also have to pray that they have not closed down the bank account to evade a garnishee order. If the judgment debtor is not financially able to pay the debt he owes to the judgment creditor because he doesn't have any assets to WSS, or he doesn't have enough money in the bank to be garnished, then the judgment creditor, that means the plaintiff, may lodge bankruptcy or winding up proceedings against the judgment debtor. For individuals, the judgment debt has to be at least $15,000 in order to commence bankruptcy proceedings. I'll discuss bankruptcy proceedings in a separate video. There's another mechanism called examination of judgment debtor. This is not a form of enforcement, but it is a court order to get the judgment debtor, that means the person who lost the lawsuit, to disclose his assets in court, to be cross-examined under oath before a judge by the lawyer, to determine what assets he has, where the assets are located. He will be asked to provide bank statements, CDP statements, He'll be asked to answer a whole list of questions under oath. The list of questions is a standard list of questions. It's available on the internet. You can go have a look at it. So, what happens if the judgment debtor refuses to attend the EJD hearing? Well, after a couple of times, if he refuses to attend the EJD hearing to disclose his assets, you can take out this thing called an order for committal, which means essentially he will be fined or he'll be thrown to jail for refusing to turn up in court. So thanks for watching this introductory video on enforcement.